Hi, my name is Chris Ukins. I'm a professor at George Washington University Law School. Welcome again to this course. It's a course on anti-corruption and procurement sponsored by UNOPS and the International Anti-Corruption Academy. We're going to be talking about United Nations guidance on anti-corruption and procurement once again. Today in Module 3, we'll be focusing on the UN Convention Against Corruption. The UN Convention Against Corruption is available in all 6 languages of the United Nations. It's available on the UNODC website, as noted on this slide. We're going to be focusing today on Article 9, which has to do with public procurement and management of public finances. The UN Convention Against Corruption, or UNCAC, is the first truly global agreement against corruption. It's the only legally binding universal anti-corruption instrument. The mandatory character of many of its provisions make it a unique tool for developing a comprehensive response to a global problem. More than 170 countries have agreed to become state parties. UNCAC has a far-reaching approach that also covers public procurement in Article 9. It seeks to draw together public procurement and anti-corruption initiatives, really a focus of this course. It is to develop a procurement system based on transparency, competition, and objectivity, which is far less likely to have problems with corruption. The UN Convention Against Corruption requires state parties to base their systems of procurement on 3 fundamental principles: transparency, competition, and objective criteria in decision-making. These are also, it should be pointed out, are 3 fundamental principles in any successful procurement system. Turning to transparency, the first principle, what does it mean? It means, of course, publicity of procurement opportunities, publishing procurement opportunities, disclosure of the rules that are to be followed and that are in conducting procurement processes according to these prescribed rules, the publicized rules, provision of a system of monitoring and enforcing applicable rules, allowing stakeholders to monitor procurement processes, ensuring the rules are followed and the non-compliance can be identified and addressed, making it difficult to disguise and maintain discriminatory procurement decisions. These are all essential elements of transparency as we've understood them. Also, it should be stressed that there are new emerging concepts. Under the penumbra of general concepts of open government, we're seeing principles of open contracting emerge. Open contracting calls for all information regarding the contracting system to be public, to be accessible, say across the internet, and also, importantly, to be machine readable so that it can be assessed across many different procurements. A procurement system depends on transparency, not only for purposes of the UN Convention Against Corruption, but more broadly to operate effectively. This is really a key concept we'll be returning to again and again in this course. The second basic principle under the UN Convention Against Corruption is competition. So what does that mean? It means, technically speaking, it means that 2 or more bidders act independently to secure a government contract. It's a key factor for governments to achieve best value for money by undergoing a contest among offerors or bidders that will offer the most favorable terms. Now, obviously, competition is going to lower prices and deliver better quality. It's also, less obviously, an important driver for innovation. Competition, this is an important point. It's worth stressing and worth thinking through. Competition encourages an information flow from the offers or the bidders to the buyer. The vendors in the course of a competition are incentivized to deliver information to the buyer. In a traditional open tender or sealed bid, as it's called in the United States, the offerors or bidders are delivering just one piece of information. They're delivering their price. But in more complex modern procurements, the offerors or bidders are presenting information both on technical and price aspects of the procurement. They are presenting to the buyer, they're presenting information on what the cutting edge opportunities are in the marketplace. In essence, the competition drives the bidders to present information to the buyer. And they're an important part of ensuring that the buyer can achieve best value in the marketplace. For this reason, not only because the competition helps quell corruption, but for this more practical reason, this more instrumental reason, competitions are a very important part of a successful procurement system. The next basic principle in the UN Convention Against Corruption is the principle of objectivity. Objectivity in decision-making aims to reduce as far as possible the biases, prejudices and subjective evaluations that otherwise might lend themselves to corruption. It's much easier to corrupt the system if there are a lot of subjective decisions being made. Objectivity is closely linked to non-discrimination, so non-discrimination among bidders, equal treatment to ensuring each bidder is treated equally. Integrity, it's much easier to ensure ethical conduct if in fact there are objective decisions being made. Also, and this is interesting, it makes it easier to have an independent and effective review mechanism. If decisions are being made by objective standards, it's much easier for another agency, for a court, to assess whether or not that decision was properly made and made without corruption. So procurement systems depend on objectivity both for their effective functioning and for fighting corruption. The UN Convention Against Corruption sets out how these three principles can be reflected in the practical aspects of a procurement system. For example, there should be the public distribution of information relating to procurement procedures and contracts. There should be the establishment in advance of the conditions for participation. For example, the qualification requirements should be set in advance for any given procurement. The use of objective and predetermined criteria for public procurement decisions should be the norm, as we've been discussing. We talked about the importance of the need for objectivity. There should be an effective system of domestic review. This is in the United States, for example, this is known as a bid challenge system, or in other countries may be referred to as a bid remedy system. This is an effective system to allow other disappointed offerors to challenge the outcome of procurement, for example, if it appears there might be corruption. Also, where appropriate, there should be measures to regulate the personnel responsible for procurement. So as we'll be discussing in a few minutes, there should be effective systems for ethics codes for those involved in implementing procurements. So to drill down on these practical implementations of the UN Convention Against Corruption, there should be a public distribution of information. It should mean publicizing contract opportunities, which is an essential tool to achieve transparency and competition. There should be a requirement under the implementing states' codes to allow for sufficient time to prepare and submit tenders. There should be distribution of relevant information on the award of contracts. Awards should be publicized as well. This is an essential requirement to achieve transparency and to allow others to challenge a possible award. If there's no publication of the award, there's no opportunity to challenge it by others. There also should be publications of the conditions for participation, as we mentioned. The conditions for participation have to be disclosed. The selection criteria, the award criteria, the tendering rules, the qualification requirements, all of these should be disclosed in advance. Sometimes they're disclosed in a particular solicitation, and sometimes they're set forth in regulation or statute. But they should be disclosed. They should be freely publicly available. Again, as part of implementing a successful procurement system under the UN Convention Against Corruption, we have to look at the responsibilities of public officials. UNCAC suggests undertaking measures to regulate matters regarding personnel responsible for procurement, such as calling for declarations of interest, so one can determine whether or not the public officials involved have a conflict of interest, screening procedures to ensure that the public officials involved aren't in fact, for example, guilty of past crimes involving bribery or gratuities. There should be training requirements as well to ensure that the public officials fully understand their obligations and to conduct ethical procurement. Procurement personnel are required to pursue ethical, fair, and impartial procurement procedures, and procurement personnel should maintain the highest standards of integrity. To complement this, these are the goals of Article 9. Article 8 of the UN Convention Against Corruption calls for codes of conduct for public officials. Just to point out, it's not uncommon to have a general code of conduct for public officials under Article 8 of the UN Convention Against Corruption, and then to have a supplemental code of conduct, an additional code of conduct that specifically applies to public procurement officials. This is often because public procurement officials are participating in higher stakes projects with more money involved, and as a result, these public procurement officials are oftentimes subject to another layer, a higher layer, an additional higher standard for ethical conduct. Now, how do you implement the UN Convention Against Corruption in a public procurement system? The UN Convention Against Corruption allows for a high degree of flexibility when shaping an appropriate system of public procurement. The requirement, again, is to comply with principles of transparency, competition, and objective criteria in decision making. The UN Office of Drugs and Crime, the UNODC, developed a checklist for meeting minimum requirements in public procurement. It's a 50-question checklist, and it's discussed in the UNODC guidebook on anti-corruption in public procurement and the management of public finances, which is also available online. This checklist is available in Annex 2 to that guidebook. You can retrieve the UNODC guidebook online. It's available in English and Spanish and Russian. Again, Annex 2 sets out a checklist for meeting minimum requirements set out by Article 9 of UNCAC. In the same vein, you may be interested in Stephen Schooner's article that he wrote for the Public Procurement Law Review in 2002. It's available on the Social Science Research Network, ssrn.com, and his article on the desiderata, or the key goals of any procurement system, helped frame some of the general principles of a successful procurement system. It's interesting background reading as you explore the requirements of Article 9 of the UN Convention Against Corruption. So you should look to the checklist for meeting UNCAC minimum requirements in public procurement. They're available again, as I noted in the previous slide, available online. You can review the checklist and then assess if the procurement system in your country, or in fact any country, meets the UNCAC requirements. I hope you enjoyed this module on the UN Convention Against Corruption. Again, thank you for joining us.